All right, Little Rock, it's time for a new show. Remember we talked about I hate real estate last week when I recorded a little bit of a solo cast talking about this new project. And you'll see I have a friend involved in this one. Please welcome my friend, Kendall Grimms.
Hi, how are you guys doing?
It's going to be great to have you on the show, Kendall, and I'm mostly excited because most agents, when they see you, kind of want to run away. No offense. But you're a real estate attorney. You're an attorney, but we think of you here in Arkansas as a real estate attorney because you're quite esteemed in that area. And I want you to introduce yourself and talk a little bit about how you got to where you are now, and then we'll talk a little bit about your current practice. So.
Sure. Well, how I got to where I am now, I went to law school, graduated in 2009, passed the bar exam on the first shot. Yay me.
I didn't pass the real estate exam on the first try.
You didn't.
So,
No.
I just want to make sure we're not on the same page.
Ultimately, the real estate, the market benefited by you eventually passing the exam.
Right. I mean, the bar exam's not as hard, but continue.
So I worked as an associate at a law firm for a few years, and some things went on there that led to the formation of my law firm, Kendel Grooms. My law partner is Don Campbell. We had an office over at 8500 West Markham since 2012. We went there in May of 2012. We've been fortunate in that when we started our law firm, we had a pretty good book of business already. We had very good clients, have always had very good clients, and ultimately ended up trying several cases, the majority of which involve real estate, as it so happens. But the largest case involving a big set of rice farmers, and it's not real estate based. We can talk about it if we need to, but it resulted in a month-long jury trial, and I spent a long portion of my legal career working on that case. It concluded last February of 2020, right before COVID lockdown, and then we moved this last year at the end of the year to our new space up at 8114 Cantrell Road, where Pulaski County title is. A lot of the real estate people listening to this probably know where they're at. So that's where we are now. But as far as career goes, I've traditionally done a civil litigation practice, mostly courtroom work, done some transactions. A lot of real estate. People probably know my dad, Tim Grooms. A lot of the real estate market knows who he is. So I get quite a few referrals from him as well. When the real estate agents screw up, his law firm represents a lot of those errors and omissions policies that if any real estate people out there listen to this, they know what I'm talking about. And so any case, any call he gets where there may be a real estate agent involved of some kind of liability, he'll refer it over to us. So coincidentally, we've done a lot of real estate work.
Well, there's a lot there to unpack because as we're talking about it too, I'm like, and then this happened and don't forget about that. Yeah. And fun enough, actually, right in the middle of you closing, I guess one of the biggest cases that's ever happened, or the biggest litigation case in Arkansas.
It may very well be the biggest jury trial that's ever occurred in the state.
And it is real estate because land is land, right? I mean, so real technically.
It was more about people not getting paid for their rice, but it involved and touched on most areas of law.
And what's interesting about it, though, like when you were talking about that case and when you were practicing that case, you were in the middle of moving as well. So you were selling your principal residence and buying your principal residence in the midst of this giant trial. Let me just add everything in the mix here and try to manage it on my way down.
I actually lived in Lone Oak. We moved out there. We rented a house in Lone Oak. The trial was in Lone Oak County, and I moved out there on January 6th of 2020. And I was out there until February the 26th of 2020, so about 7 weeks. And in that, the first weekend after I was there, I actually came home and on that Monday and we closed a real estate transaction. And God bless my wife, she moved to the entire house, everything without me.
I think it was January 7th.
Yeah.
I think that's what the closing date was. And this is what's funny about it is I know we have that relationship and I'm excited to have you here today, but that's kind of what led me into really discovering how deep your knowledge of real estate is, because through that process, I'm like, what is expert testimony? What do you mean this guy is getting paid to talk about his expert opinion and or being pulled into court? And so you told me a little bit about expert testimony, and you've sort of formed, you're kind of like the badass. Everybody talks about you as a real estate attorney, and you have all the best experts. So I'm esteemed, feel like a part of the cool kid club that I get to be an expert for Kendel Grooms. But tell me how that came about as well.
That's one thing that every litigation firm has. You build a team of experts that you trust, that you can take into court with you, that you know are going to give you the truth, what you need to hear, and are not just going to tell you what you want to hear for the purpose of being paid. They're going to tell you the truth.
You can't handle the truth. Sorry, I've been waiting to say that since you got here.
You had that one ready to go too.
Yeah.
But it started in construction, really. And we did several of the first real estate cases we handled were construction based. And so we developed a team, a couple of engineers, a construction person that can testify. And so that kind of built into where we ended up with additional experts. Then we had the Rice trial. And in the Rice trial, we had a technology expert because we had a lot dealing with text messages and phone records and everything else. And then just recently we've had, I think you're involved in 5 of our cases now. And I have to give a plug for Jamie because we actually tried a case last week, 3-day trial. Jamie testified on the second day of that trial as an expert, first time to ever testify. And I've already told her this, so this is for the record, we'll put it on.
Yes.
She is one of, if not the best expert that we've ever had testify for us in a trial.
Thank you.
Yeah, it was amazing. She pretty much tore up another lawyer.
Well, thank you. And I'm so excited because literally that's the culmination of this podcast is I do not have the discipline to go to law school, but I love the drama of it. And I have a lot of knowledge about real estate. So the two come together and they marry really well in the opportunity to be an expert witness. The other thing is both of the avenues in which I've been licensed over the years, real estate and appraisal, have very clear indication on the front end, like, hey, we're here to maintain and promote the trust of the public. We want the public to feel competent in our performance as a professional. And because of that, you can trust us, you can count on us. And almost all the ones I've seen or litigation, anything I see is always involving like some professional didn't let someone know something, or there was a lack of disclosure, or there was something that should have been said that wasn't. And that kind of gave me the idea through our relationship and through all these happenings to start this podcast called I Hate Real Estate, so we could really talk about the parts we hate, because there are parts we hate. Correct?
There are.
For the record, there are parts we hate. So I'm going to jump right into it then, and we'll kind of continue to talk about you as we continue to build this podcast, and our audience will learn more about us as we go. But let's jump right in here because we're in Arkansas, which is a non-disclosure state. So a lot of state investors will call me and they'll say, hey, I'm real interested in this property or that property. And the first thing that normally comes out of my mouth is 2 things you need to know. We're a dual agency state and a non-disclosure state, which means agents can work on both sides of your transaction, number 1. And number 2, if you're not working with an agent, you really don't have to disclose anything. Technically that is true. Mm-hmm. So kind of expound on that a little bit before we go into the page 4, which is the issue of the day. Tell me a little bit about working in a non-disclosure state and how that comes up in litigation. Well,
most of the transactions that we deal in are on the form contracts. And so the form contract does create the requirement to make a disclosure, but otherwise, and I actually argued this in court to Judge Huckabee in Lonoke County last week, was that, yeah, it's true, Arkansas is a non-disclosure state unless you have a contractual obligation to give a disclosure,
or
a true and correct disclosure.
Or you sign a disclosure?
Yeah, or you sign a disclosure, even if you don't need it. If you make a representation of the condition of a property, even if it's not under a contract, then, yeah, you've made that representation. If it's untruthful, that's a problem for you.
And so a lot of times it comes up to where not the disclosure is not the issue, because the seller usually, if there's an issue, has not disclosed something. So when we get to the page 4 issue, what I'm referring to is you said contracts, and in Arkansas we have some amazing contracts. I know a guy who wrote them. The Arkansas Realtors Association has fill in the blank contracts, as we call them as realtors. There's just these blanks in there. We are not allowed to do anything on top of that because that would be the practice of law, the unauthorized practice of law. So we just fill them in and we send them off to our client for execution. We advise our client as we walk them through what each of these terms mean and what they mean with respect to that particular transaction. Now, that being said, Arkansas has absolutely no room for misunderstanding on this issue, correct? Is there any way that we can write another contract and put it on top of the ARA contract?
No.
Just making sure everybody knows that.
Yeah, no.
So that being said, there is a ancillary paper to the real estate contract, and every state probably has their different version, but ours is called the Inspection Repair Survey Addendum. And this addendum is back and forth between 2 parties, the buyer and the seller, through their agents, their fiduciaries. And this thing goes back and forth, which is why agents hate it. Let's be honest. No one's holding on to the first, second, third, fourth page. Yeah, no. And if it just went across once like a real estate contract, we'd have a lot less problems. But it goes back and forth. And on page 4, it basically says, you accept this property exactly as it sits.
You've done every inspection you want to do. You've seen everything about the property, every nook and cranny. You're completely satisfied with the condition of the property, is I believe what it says.
You know how when you're getting married, and I don't know because you're not like a justice of the peace, but you might have this in your mind as well, but like, does anyone object? Is there any reason? Like, that is your opportunity on page 4.
That's right.
I object. But if you sign that page, it's very hard to get out of it, right?
Absent some kind of fraud being committed, yes.
Right. So we're going to talk a little bit about some page 4 issues. And we're just going to talk about me today since we don't have a guest here, and we're going to be bringing guests on in the future. But I am a failure to communicate here on page 4, my very first time out of the gate as an agent. This is one of the things that makes me a great expert. I've been in these situations firsthand. But the very first time, really the only time I've made a contractual error in real estate had to do with page 4. My buyers were coming in out of town on a personal referral, and they were moving into town, and I'm not familiar with the area, so it was kind of up to me to find the right neighborhood based on what they needed. So I brought them. They fell in love with the house. We got all the way through the lending process. No issues with appraisal, inspection. Everything's great. So we just go ahead and send off page 4. My husband and I are working at a team. We've been in real estate for maybe a year at this point, and we're used to the fact that when the seller makes repairs, the buyer agrees, and they go back and forth, and then we sign page 4 the day of the walkthrough because we're looking at the house and we're all happy. And we sign the page. We send it to the other agent. I've accepted the house in this condition, and off we go. I was not informed we should probably close the actual closing paperwork at the title company and then go look at the property to make sure that it's in that good condition we accepted in finally, and then sign the paperwork. So we skipped off with page 4 signed to the title company, and we closed our real estate transaction. And then I called the other agent and I said, hey, we're done closing. We're going to run over and just do the final walkthrough, and that'll be that. She said, you already gave us page 4, and we don't sign until later, so you're not going in there. And I was like, well, red flag. Why can't I go in the house that my buyer just funded the loan on, where we signed the paperwork saying that we accept it? And you're so serious. Your face is so serious because you know there's about to be some big issue. And I'm like thinking I'm going to surprise you.
Not going to be surprised.
She charges me $500 to walk through the house. I'm like, I'll pay you.
That's
like,
insane.
That's crazy. It's crazy that she let me. I can't believe she let me do it. So I gave her the $500.
It's insane that she charged you $500 in the first place.
I know, but here's the worst part. Just give it back to me because now I have to replace all the carpet. We walked into the front door. I'm sorry. I just yelled. The producer's like, I hate her on volume. She's the worst. Anyways, I'm a great host. That's all that matters. We walk in and there's literally like, might as well be a murder scene. Like, it's a huge red, brown, like something died right here stain. And it's covered by this beautiful carpet. And I'm like, oh, hey guys, did you see that when we looked at the house? And they were like, no. And we're definitely upset and we definitely want this fixed. And I'm over here $500 short of a new carpet. We ended up paying, as much as we could to have it cleaned. It wouldn't come out. They eventually have to replace the flooring altogether. Luckily, it worked out on a relationship basis. They knew it wasn't something that we intended to do. Tell me what you do in that situation. A realtor comes to you and says, oh, what do I do? Do you just immediately tell them, well, that's what page 4 is for. You shouldn't have done that. Or do you say, okay, I'll take your case and try to justify it? I mean, first of all, tell me what you do if I come to you with it. And then secondly, let's jump into the license law and figure out where I went wrong.
My understanding based on what you just said is you ended up covering the cost of the new carpet.
I did. That's why there wasn't litigation.
Yes, you probably did the right thing because the final walkthrough, the pre-period before you sign that page 4 of the inspection, repair, and survey addendum, that's your opportunity to do the final walkthrough. The contract says you're entitled to inspect as many different times, as many different ways as you want to, up until closing. Well, since you went and signed the paperwork first to close, in theory, your person was the owner of the house. You shouldn't have even had to pay the $500 to go see the house. No. You're the owner at that point in time. But you had a right under the contract to inspect it as many times as you want to. And so the signature on that page 4 probably locked you up. And if it was that obvious when you walked into the house that there's this huge murder stain on the carpet,
it was covered by a rug.
Certainly, if a final walkthrough had been done, it would have been found or spotted. Now, if it was covered up by a rug, you may not have noticed on a walkthrough, and it may have been covered up for that very purpose. And that's where you get into the legal side of, was there a fraud? Was there a cover-up? And
we didn't even think to go back and be like, why didn't you disclose it? Because sellers are not probably going to write, and that would be really easy to get out of, like, oh, I forgot there was a stain on the carpet. That's pretty easy to forget. I mean, there are things I've seen people to leave out of their disclosure that are far more noticeable. But I mean, what if they said that? What if they said, well, I didn't put it on the disclosure because it wasn't noticeable? And what if I fought it on fraud? Like we wouldn't have bought the house if we knew there was a murder stain. I mean, technically this isn't a murder stain. So
no,
maybe
it's not a murder stain. We don't really know what it is.
This.
We keep calling it
this could be spaghetti. So
let's
spaghetti
let's just not give the address of this home on the podcast.
Yeah, we'll never give addresses and names as a disclaimer. I guess I probably should have. You're supposed to tell me to do the legal disclaimers on the front end, Kendall.
You're the host.
Oh, okay. Well, Kendall said we can't talk about addresses and names.
Yeah.
Okay. But seriously, even the spaghetti stain, even if we had noticed it, my big thing is I was a new agent. And even walking through contract classes, like no one had pulled me aside and been like, hey, if someone decides to screw you over, you need to be totally prepared. So look in every nook and cranny because there could be a host of wild hornets living under the kitchen cabinet and they're endangered. And now your people can't live in that house.
First off, if you had a stain on carpet and you discovered it even on a first time you ever saw the property, you'd be making a demand for some kind of
allowance.
To get the carpet replaced in that area. So we're not talking about huge damage here. We're not talking about a foundation problem or a mold problem or something along those lines. But with respect to the final walkthrough itself, I think based on my experience from what I've seen in these cases we've worked, clients we've talked to, even people whose cases we haven't taken because of other issues with what they knew or didn't know, I think that both home buyers and real estate agents do need to make it a better practice of what they do during this final walkthrough before they sign page 4 of the inspection, repair, and survey addendum, because that's really where the problem arises, is people go look at the house the first time, they get an inspection done, they get a home inspector to come in. Home inspector says, yeah, there's nothing major wrong with this house. You fill out the inspection, repair, and survey addendum with a few small items that you may want fixed, repaired before you actually take possession or close. And then when you go back to do the final walkthrough, a lot of people will just say, oh yeah, this knob that I wanted that was loose, it's fixed, so it's good, we're out of here. And They're there 10 minutes and they leave. But that's technically your opportunity. You have an opportunity at that point to walk through the house and say, I found something that I'm very dissatisfied with. I'm out. I'm not closing on this thing. And so you get to this point of, what do? Do you just have to go check on these items that you requested be repaired? Or do you actually have to take a flashlight and get in the bottom of every cabinet on your own after hiring an inspector and make sure that there's not mold growing in the corner of a cabinet? And that's where this fine line is of what we're talking about with page 4 today of, I'm completely satisfied with the property. Well, if there's parts of the property that you've never looked at, or that an inspector's never looked at, or that an inspector says, I'm not going to check this for you if you really want this checked, get somebody else to do it.
Right.
What's occurred now that you've signed page 4 saying I'm completely satisfied? And from a legal standpoint, that's an argument that's often made by people who are defending themselves against fraud or other claims under these contracts.
Yeah, I actually just popped in my head why page 4 was never brought up in our situation.
It was brought up.
Was it?
Well,
I wasn't there.
Page 4 was brought up. The thing that wasn't brought up in ours, and this is a different topic for a different day if we decide to, but the contract itself has a buyer's disclaimer of reliance in it.
Yeah.
And the buyer's disclaimer of reliance, in short, just says, you're not relying on anything that an agent or the other party is telling you.
It's me.
Yeah.
Mm-hmm.
Yeah.
It's weird because the seller disclosure says that too. And it's almost like some people just like look over that. But that being said, you're talking about page 4 being something that people can actually go into court and defend themselves and say, look, you signed the piece of paper. I might be the seller and there might be a spaghetti stain in my living room, but you signed page 4. It is what it is. So in our situation, like you said, is a small damage. What happens when it's a big damage? And you're looking at some right now that looks juicy.
No,
Anytime there's a lot of pages on a lawyer's desk,
yeah,
it's juicy.
Yeah. Well, I brought some cases with me. We actually use these cases all the time because they're on point on these issues. The majority of the cases that I handle that involve the real estate contract and these types of claims that you're satisfied with the property are these seller's fraud claims, really it's a buyer's fraud claim where the seller is alleged to have committed fraud and not disclosing something in the seller's property disclosure. And so a common defense is, well, you've got fraud. I'm not going to go through the whole law school definition of fraud, but one thing you have to do is you have to have some reliance on the statements that are made.
Right.
Like if I tell you something, Jamie, you have to rely on it as being a true and correct statement.
Right.
So there's been a ton of cases out there where this has happened because the defense lawyer on the other side will come in and say, well, hey, hang on a second. You signed this document that said you were completely satisfied with the property on page 4 of this inspection, repair, and survey addendum, and now you're telling me you're not happy with it anymore. So you found something, you've discovered something. Well, you had all this opportunity to inspect. You had an inspection. You had a final walkthrough opportunity. And now you've signed this thing saying...
Your story changes. All of a sudden, your story changes.
Yeah.
So
the fact that buyer completes the purchase of this property warrants that the buyer is completely satisfied with the condition of the property. Anybody listening to this, including you, Jamie, sitting on the other side here from me, can tell why that seems problematic for someone claiming they've been defrauded.
Yeah, that's kind of an issue because I've signed a piece of paper saying, look, I love this house, even though there's a giant spaghetti stain on the living room floor that I may or may not know about. But when there's defensible action like this, let's say, okay, like how do you win a case like this, though? In my situation, it's small fry, right? It's a good one to start on, but this can get really serious. So what happens? Give me an example of a seller doing something awful and a buyer signing page 4 and getting kind of screwed into the house because they were, quote unquote, completely satisfied.
Let's talk about our case we just had last week.
Okay.
I mean, we can.
I like that one, but I wasn't sure if it was too
No,
fresh.
it's fine. It's fine. It's public record now. So.
And it's true, though, because that was a situation where page 4, for them, the buyers could have gone back and looked at the house, and unless it was pouring down rain, they would have not been unsatisfied with the house.
Correct. And so in this case, we have an issue where man lives over in New Mexico, and he moves to Arkansas. He married someone in Arkansas, is going to move here. They buy a property. He buys a property. And his wife had a previous issue with flooding at a house.
For those of you who don't know, buyers can be sometimes wary of purchasing property in the way of floodways, flood zones, or water issues.
And she had an issue with a flood at a previous house in Jacksonville, Arkansas, that she lived at, and her 1-year-old could have died in the flood, and so she's overly sensitive to the situation. One of the first things she does is every house they look at over 60 houses in and around Jacksonville, Cabot, that area, and one of the very first things she does is go to FEMA and say, is this property in a flood zone? And because she's very concerned about it. Well, come to find out, they buy this house. They love this house, buy this house, great location, just what they wanted in their price range. Checked all their boxes as far as, square footage, how many bedrooms it has, that kind of thing. They find out later on from a neighbor that the street, this cul-de-sac where the property's at, and the home have had all kinds of water and flood issues. And come to find out, there's a news story about it. There are photos, including one photo with the people who owned the house that sold it to them standing there looking at the floodwaters in the front yard.
With a for sale by owner sign in the yard.
While it's for sale to the public. Of course, none of this is disclosed. They fill out a seller's property disclosure where every box is checked no, except for one that was not applicable, but it didn't matter as to water. And they say there's no flooding, drainage, standing water on the property.
No external obsolescence.
Yes, no external obsolescence, one of my favorite words that I've learned about. And so as the trial goes on, and the case goes on, we've alleged that they committed fraud. Our people would have never bought this house. Anything that was in a flood zone, anything that had a disclosed water issue was automatically stricken from their list. It doesn't matter how nice the house was, how good of a deal it was.
I don't want this one. There's
don't
water.
want this house. If there's a water problem, I don't want it. I've had experiences with that before that were very negative. Don't want to go through that again. Don't even want the possibility of going through that again, because water had never actually entered this home that was part of the lawsuit.
Right.
And so, but it's close enough that don't
it's
really
pretty
want to deal
damn
with
close.
it. Yeah, it's pretty close.
Even if it wasn't that close, for the record, the quality of life associated with a yard like that, I mean, if you don't know going into it and you've got a bunch of kids and your yard's going to consistently have a river in it, like, good to know up front, because I know that I would choose a different house now if I knew when I knew. Of course, that's my husband. He bought that house before me.
Sure.
It's not my choice, not my backyard. But anyways, I would have been more careful about it. But what Kendall's talking about too is these people had no ability to actually walk in and around this house every day leading up to closing because they were moving to Arkansas from out of state. So they're relying on their real estate agent, the home inspector, the appraiser, and all of those people being stripped of proper information because the seller disclosure not being filled out properly leads to the situation where they have no idea what's going to happen. And they wake up to this nightmare of, okay, now we live in a house that has totally had water issues, always has had water issues. We've been duped, and they feel duped because why would you not tell someone that? But they've signed page 4. And they've closed on the house, so they were, quote unquote, completely satisfied.
Yep. And that's the argument. And so what the case law says, though, is even though you signed this buyer's disclaimer of reliance in the contract, or you've signed page 4 of the inspection, repair, and survey addendum saying you're completely satisfied with the condition of the property, Arkansas law says that fraud undoes that.
Well,
if you don't
thank you, Arkansas state law.
Thank you, Court of Appeals, Arkansas Supreme Court. There's multiple cases, and I pulled 4 of them. 2 of these cases, actually, I think they're all 4 Arkansas Court of Appeals cases, so I'm not sure that the Supreme Court has ever actually considered this issue. I only printed 3, not 4. But that's what it says. They've come out and said, if you commit fraud, you don't get off the hook because somebody signed that they were completely satisfied with a condition of which they did not know.
Yeah, so your loophole, Mr. Seller, where you're trying to dupe this buyer is not going to work because they can sign page 4, but if you freaking lie to them on the 8-page seller property disclosure, going downtown because Kendall Grooms is going to take you out.
And the podcast being that we hate real estate doesn't mean we hate this. We don't hate that the case law has been developed to say if you do try to commit fraud against someone, if you try to hose somebody you're selling it to and you think, well, we'll try to cover that up a little bit. If they find that out later on, you're not off the hook just because they signed some document saying they were completely satisfied with the property or that they weren't relying on what you said.
Well, and that's one of the reasons why I actually want to start this show. I mean, there's two things, and I think it's great because us coming together is, last week and I was talking about doing this and then talking about introducing you, and then next week bringing on our first guest to talk about their experiences. You don't hear about this side of it. Sometimes you'll see these case law when you talk about it. We bring up a specific subject and we talk about it. But when you're buying a house, it's always like, aren't you so excited to get your kids home into the new yard? Or aren't you so excited to be in this new area of town or this new state? And I hate real estate when it comes down to, but then the seller lied and then I found out this later and then I overpaid or now I can't sell and I've got to move out of state. And I don't know why these professionals and this industry has yielded such a great amount of positivity, and no one's even looking at all the other stuff that's going on. That's why I really wanted to start the show, because this could be some pretty ugly stuff.
Yep. And it's, with the seller's property disclosure form, as it applies to this, I'm of the opinion that if you check yes on a box, if you're asked, is there flooding, drainage, standing water, if you check yes on that box, even if later on when you're asked to describe the situation where you checked yes, later on down in the form it asks you, put the number where you checked yes and describe what's going on. Even if you describe the wrong thing, I'm of the opinion that you have not committed fraud.
You at least tried.
Because then you've put the person buying the home on notice of, hey, there may be flooding, drainage. Even though this is the reason, there may be other ancillary things that arose from that could be problems that may not want you to purchase the house. And you are then on the hook for performing inspections, investigations, those types of things. So it goes back to what your advice would be. If you have to call your realtor and say, hey, should I disclose this or not? What's the answer, Jamie?
You definitely should disclose it.
Absolutely.
Always 100%. But I'm of the opinion too, and we've talked about this, where I'm just an open book. And that sometimes loses me more listings than it gets me, because I'll just tell a seller like, it's not worth it. Also, your house sucks. And I'm not going to, I'm just saying there are those houses that suck. And there are people, like I have clients right now that have come to me, via you. And I'm like, ooh, you have to disclose everything. And how do we set that up? And how do we disclose it to make sure that we don't, the property is going to be stigmatized a little bit anyways, but how do we make sure that we expose to the public, look, you have the opportunity to purchase this property, but here's everything else you need to know about it. And that brings me to another question. How come you can't Carfax your house?
I think you could Carfax your house. It's just a matter of
calling the insurance company, I bet.
Well, yeah, it's a matter of pulling together the information, because a house doesn't necessarily have a standard VIN number like a vehicle does.
It has an address.
I know, where it's registered nationwide in all these databases and systems. The only thing that you really have with an address is for the purpose of 911, knowing where you are, and the mail and the postal service.
This is an emergency. I need to know what happened here before I bought this house.
Yeah, exactly. And then you have like a parcel number, but that's strictly for assessment and tax purposes. So there is no national standardized number like you have with a VIN number on a vehicle.
Yeah, well, we're going to get there someday. What we're going to start with, though, is digging into these cases one at a time when we get people on here to talk about their worst experience in real estate. So before I let you go, I do have to ask you a couple of questions, and I'm sure that they were pre-me, if you had any, because obviously I'm a consummate professional.
You've answered all of my questions.
Oh, I know that, but I was going to say if there's any issues you've had in real estate, they were before me, because obviously I'm consummate professional, but
that's right.
Prior to. Did you ever have a moment in case law or in real estate, and maybe it's this case, maybe it's another one, like just this moment where you're like, I hate real estate? Because before you tell me mine, I'm going to tell you that after working on that case, you engaged me in July of 2019. I believe we closed in 2021. So in that whole process, I worked hard. I thought I never even got to meet the clients until court. And then I go through the process and I listened to the seller who has blatantly lied on paper multiple times. We would never, ever lie about that. We're just not those kind of people. And I just looked down and thought, I hate real estate. Yeah. Do you have one of those?
To be honest with you, I don't have one of those, because for the reasons that you hate real estate are that's the same reason why people keep coming to me for legal services. So, the issues of where someone that's an agent like yourself or a broker that would hate real estate is the very reason why lawyers exist. Mm-hmm. And nobody wants to be a lawyer. Nobody wants to meet a lawyer. No one wants to especially be in a situation where they're around their lawyer enough for a legal matter to become friends with that lawyer. It does happen from time to time because we are human beings. We're mostly nice people.
Yeah.
But no, the reason you hate real estate is the reason why I end up getting involved in real estate actions.
Well, I think we're going to have a really good time on this show because we have sort of a love-hate relationship. You can keep loving it and I'll keep hating it. Right. And we'll bring our guests on and we'll expose more of the dirty details behind what happens in real estate transactions when things don't always go the right way. So, Mr. Grooms, thank you for your attendance this morning.
Well, thank you for having me here, and I look forward to going through this with you.
I do too. This podcast is adjourned. We need to get him a gavel. Make a note.
Yeah, we do.